In 2004, Brian Johnson, a Native American man, was the victim of a tragic homicide. In a suit for damages, the court calculated the amount Johnson's family should receive for his lost future income. They hired Dr. Paul Randall, PhD and professor of finance, who for over 30 years had performed thousands of lost income calculations. He ran the numbers. Johnson was a high school student, 21 when he was killed, probably would have worked for about 40 more years, and on and on. Randall came up with $433,000. The judge then asked a question that Dr. Randall had never heard before. What happens if you ignore the effect of Mr. Johnson's race? Well, in that case, Dr. Randall's formula spat out a completely different number, $744,000, far from Randall's first calculation of $433,000. So how did he get there? Randall started with $744,000 and multiplied by 58%, because that's the ratio of what Native American men in America earn compared to white men. The difference was huge. Plus, that difference of $300,000 today is worth even more in the future. And remember, this money was going to Johnson's mother, who had lost her son forever. At the end of any trial, we expect an award. The question is never just who wins, but what does that winner get? That depends on what the victim could have earned had they not suffered the harm. It's the make-whole doctrine of damages. But how do we get to that number? Judges and juries can't see the future, yet we're asking them to do just that. Enter predictive tables. These tables take into account life expectancy and projected wage loss for an individual. The catch? Each race gets a different table. Expert witnesses, judges, and juries use these tables to calculate damages. Why do we use these tables? Well, first, they're easily administrable because they provide a fast and easy way to calculate damages. They're efficient because plaintiffs can weigh the costs of litigating against their potential damage award. They reduce judicial and jury discretion and therefore produce consistent results. And lastly, many believe these tables are statistically accurate and correctly predict outcomes. But what are some potential problems? For starters, the tables are based on outdated data. They focus on groups over individuals and situations. But what about individuals who don't fit neatly into one of these prescribed groups, like mixed race individuals? Or more problematic is that we're validating the belief that your earning potential is based on your race, and we're doing it by using numbers that reflect a historically and currently racially unequal society. Consider the connection between these tables and the problem of mass incarceration in America, as explained by Professor Martha Shamalis, a tort law expert at The Ohio State University, Moritz College of Law.
And when you use race-based tables, generally they predict that African American men will work fewer years than white men. And one reason there's that lower prediction is that so many African American men are incarcerated and they're not working while they're in jail. When one is making this assumption that the kind of present mass incarceration determines the potential of particularly a young black child, that's really racially problematic.
In the past, this racial inequity was a lot more explicit. In a 1909 case, a black man was awarded $2,500 in damages. The judge reduced these damages from $2,500 to $300, explicitly because of his race, stating, in one sense, a colored man is just as good as a white man, but he has not the same amount of injury that a white man would have. The amount of evil that would flow to the colored man from a charge like this would not be as great as it probably would be to a white man. But you might say, oh, that was 1909. We don't award lower amounts to minorities or women just because they're minorities or women. That's why we have tort tables that look at objective factors instead, like your earning potential. Our question is that really true? Or do the tort tables allow us to hide behind a veneer of objectivity? Not sold? Consider what happens if we continue to use these tables in a widespread way. To begin with, lower damage awards make plaintiffs' lawyers much less likely to take on a case for a minority plaintiff. Contingency fees are pegged to damages after all. With no threat of litigation, there aren't as many incentives for those perpetrating the injuries to stop. And even if plaintiffs do litigate, our current system means the incentives to stop perpetrating injuries are still lower when the victims are minorities. Take the example of lead paint cases. Black children are nearly 3 times more likely than white children to have elevated lead exposure. but minority children systematically receive less in damages than white children. As a landlord or a municipality, it's cheaper to injure minority children, so there's less incentive to fix the issue in a minority neighborhood. Tort reform exacerbates the problem by trying to reduce non-economic damages. Minorities stand to lose the most because a far higher proportion of their total damages is non-economic. Perhaps most problematic, though, is what this says about how we view the racial divisions in our society. By relying on historical wage data via the use of these race-based tables, we are perpetuating the disparate treatment of minorities in the workplace and resulting wage gap.
The basic use of the tables presumes that the patterns of the past will be replicated in the future, and not just in the next 5 years, but the next 50 years.
So what can we do about it? Some courts have moved away from the use of race-based tables by either relying on one single table or doing away with them altogether. Consider the September 11th Victim Compensation Fund. Originally, the fund planned to compensate victims' families using race and gender-based tables, meaning that the women and minorities who lost their lives on 9/11 would be worth less than white male victims. Administrator Kenneth Feinberg chose to eliminate those distinctions and relied only on white male earning tables to equalize the awards for each victim. In Torpedo versus U.S., the court awarded a mixed race plaintiff damages based on a blended table that combined all races. In the 2008 Staten Island ferry crash case, federal district judge Jack Weinstein completely rejected gender and race-based calculations. He stated that the use of race-based tables to calculate a tort victim's damage award was unconstitutional, stating, "Using these statistics to calculate future economic loss reinforces the rigid racial and ethnic barriers that our society strives to abolish." Many questions remain unanswered. Since most cases settle outside of court, how do the tables influence settlement offers? If closing the wage gap is important, why are we perpetuating the problem in the courtroom? Why are we choosing white male tables in some cases and race-blended tables in others? How do we keep implicit bias out of this decision? These are our puzzles. Can you solve them?